Welcome to the 8th edition of World Intellectual Property Forum.
Hello everyone, my name is Venkata. Raghavan. I'm the proprietor of Escalade Legal Services. So we handle both IP litigation as well as prosecution matters in India. Firstly, I would like to thank World IP Forum for inviting me on this platform. Today I will be talking on the latest trends when it comes to IPR enforcement in the digital space focused in India. So, one of the first cases which I would like to discuss today is the World Wrestling Entertainment case versus Messrs. Reshma Collection. In this case, the plaintiff was a US corporation while the defendant was from Mumbai. This case was first initially filed before a single judge before the Delhi High Court, and wherein the plaintiff's advocate in this case had cited section 134(2) of the Trademarks Act and also section 62(2) of the Copyrights Act, wherein the provision allows for the plaintiff to file a case where he or she carries on the business and personally works for gain. So the single judge the single judge before the Delhi High Court in the instant case, while considering section 134(2) and section 62(2), vis-a-vis also considering all the other documentary evidence which was provided by the plaintiff's advocate, and considering that the plaintiff was from US and the defendant was from Mumbai, held that the court did not have jurisdiction and returned the plaintiff. This case was then later challenged before the division bench of the same Delhi High Court, and the division bench, of course, made very interesting observations and eventually reversed the order of the single bench of the Delhi High Court. Some of the most important things which the division bench in this case observed while actually reversing the order of the single judge of the Delhi High Court was when a transaction takes place over the internet where the contract will be concluded. The same, the division bench of the Delhi High Court also considered the same cases, one of the case being the same very famous Doda case, wherein the Supreme Court had initially laid down a three-pronged test to determine whether the plaintiff could be said to have been carrying on business in a particular place. So what are those three conditions which was also considered by the division bench of the Delhi High Court? The first one being is that the agent must be a special agent who attends exclusively to the business of the principal and carries it on in the name of the principal, and not as a general agent who does business for anyone that pays him. The second one being the person acting as an agent must be an agent in the strict sense of the term, and a manager, and not a manager of a joint Hindu family, cannot be regarded as an agent within the meaning of this condition. And to constitute carrying on business at a certain place, the essential part of the business must be performed at that place. So the division bench of the Delhi High Court then went on to consider whether the essential part of the plaintiff business was actually performed in Delhi, because in this instant case the plaintiff was from US, and of course he did not have any establishment here, while of course so many business transactions were happening in Delhi and in other states as well. The other point which was considered by the division bench is when a transaction takes place over the internet where the contract is concluded. The same division bench also referred the case of Bhagwan Govardhan Das Kedia's case, wherein in this case it was held that the general rule is that the contract is complete when the offerer receives intimation that the offeree has accepted the offer. So in this case, with the point of view of considering the judicial forum, wherever the offeree has accepted the offer which was made by the offerer, so the place where the offeree has made the acceptance shall be considered for the sake of the judicial forum, and in that forum the case can also be filed. So this was another observation which was made by the division bench of the High Court. So, and then it went on to actually go into the specifics of this case and said as to where the plaintiff, being a US organization, of course, had sent many communications to Delhi, and wherein while sending many communications, business related, transactions related, and since those communications and transactions were accepted by customers in Delhi, cannot be said that actually it was concluded in Delhi, and since it was concluded in Delhi, that is why it can be said that Delhi would be the jurisdiction where the plaintiff carries on business, and hence the division bench of the Delhi High Court reversed the decision of the single judge of the Delhi High Court and held that the plaintiff had the jurisdiction in the instant case. Coming back to another case of the Banyan Tree Holding Limited versus Murali Krishna. This is another interesting case because in this case, what has happened is both the plaintiff and the defendant were not from Delhi, and this case was filed before the Delhi High Court. So, and this was pertaining to a passing of the plaintiff's trademark, as well as the domain names which were deceptively similar to the plaintiff's trademarks were being used by the defendant. So in this case, not having an absolute idea, the then Honorable Justice Ravindra Bhatt referred the matter to the division bench, hoping to find an answer to this and to settle the law when it comes to passing off actions where the plaintiff and defendants were not from the forum in which before which it has been filed. So the court held that merely accessing a website in Delhi for which this was filed will not satisfy the exercise of jurisdiction by the Delhi court. And also the division bench in this case went on to actually say that it has to be shown that the defendant purposefully availed itself of such jurisdiction by demonstrating that the use of the website was with an intent to conclude the commercial transaction with the site user, and such use resulted in the injury or harm to the plaintiff at Delhi. So this was an observation which was made by the division bench of the Delhi High Court. Later on, the Honorable Court further went on to say that the plaintiff will have to show prima facie that the website, whether termed as passive plus or interactive, was specifically targeted at viewers in the forum state for commercial transactions. So these were the observations which was made by the division bench of the High Court, and hence the case was later disposed of as saying that the plaintiff did not have a jurisdiction to file the case before the Delhi court. Another concept which I would like to discuss are dynamic injunctions. Now, what is a dynamic injunctions? When a plaintiff files a case against the defendant for purportedly any kind of a link which is there and which is for which plaintiff is the owner, and it has been proved by the court, before the court, by the plaintiff that he is the owner, and by using this content on the defendant's website, it is infringing on his work, then an injunction can be granted. In case of dynamic injunctions, what happens is, if the same content is then used by either the same defendant, or if it is used by any other defendant, that is the same link, then the plaintiff does not have the headache to again go to the same court, go through the same cumbersome process to explain how he or she is the owner, and then remove the link. Directly what the plaintiff can do is go before the registrar, the joint registrar, but provide all the documentary evidence to show by way of an affidavit that the latter, again, maybe it might be the same defendant through some other forum, or it may be a different defendant altogether, showcase before the joint registrar as to how previously an injunction has been granted, and the same injunction can then be applied to the subsequent infringing work as well, and then he can claim the benefit of the already granted injunction. So these are dynamic injunctions. So the Delhi High Court has been very proactive, and in a recent UTV versus others case, the Delhi High Court issued the very first dynamic injunction. So some of the main important things which was considered in this UTV case by the Delhi High Court is, should the infringer of the copyright on the internet be treated differently from an infringer in the physical world? The court actually went on to hold that it is no different. Of course, it should be treated in the exact same manner. And of course, if it is found that what he or she is using is a content which is being infringed on any other's IP, then of course they should be stopped. The next question is, by actually granting, by seeking blocking of the website dedicated to piracy, does it make one an opponent of free and open internet? The court went on to observe that just because we are stopping others, but in fact we're stopping those who are infringing the content of IP owners. So that being the case, definitely by doing so, it does not amount to being as an opponent of a free and open internet. The court also went on to discuss about rogue websites. Now this is a very interesting concept again. So the Delhi High Court in this UTV case went on to borrow what is known as flagrantly infringing online locations from the High Court of Singapore for rogue websites. Now what are these rogue websites? Rogue websites in a layman term are generally websites which generally host a lot of infringing material, illegal material of course, which may be in fact to a great extent they don't deliberately infringing on other IPs. So these are these websites. Of course, we have also heard of the dark web, and most of us may also be familiar of what dark web is all about, which pretty much hosts only illegal content, and quite a few unfortunately illegal activities happen on the dark web, which is not accessible to us using maybe like say a Google Chrome or an Internet Explorer. You have an entire different ecosystem altogether when it comes to dark web, which has its own server. So now coming back to this case, so what is a rogue website? The court also discussed factors which would help in determining whether the website is a flagrantly infringing online location. So which includes the primary purpose of the website was to commit the infringement, the flagrancy in infringement, or flagrancy in facilitating the infringement, whether the registrant details are masked. Of course, once you go to the whois database, maybe they'll try much more than what is required to actually protect the details. Maybe even use proxy servers or anything equivalent there to divert to some other registrant to mask themselves or to camouflage themselves. Then the inaction by the website on receipt of takedown notices, even though you send many takedown notices saying that you are infringing on the content, still when they don't take it down. Whether the owner or operator shows disregard for copyright generally, any other order from a foreign court that has been disabled access to such website, and volume of traffic or frequency of such access of websites. So of course these rogue websites are websites which deliberately with an intent, with full actual knowledge, run these websites hosting many illegal content. So these are the rogue websites, and of course it is not only frowned upon, and this is one of the topic which was discussed in this case. The other question which was discussed in this case was, is the test for determining a rogue website a qualitative or a quantitative one? So in this UTV case, the court actually referred to the Eros International Media case, and which held that the Bombay High Court held that a qualitative approach was given preference in the light of presence of non-infringing or legitimate content on the website, and hence injunction was not issued against the website. On the other hand, in another case of Department of Electronics and Information Technology versus Star India, in this case it was held that blocking the entire website was in fact the best solution, instead of identifying each offending URL, because that would have been a humongous task for the court. So hence it felt that blocking the entire website felt more prudent, and hence it was of the opinion that if the test is to declare whether a website as a rogue website is that it should contain only illicit or infringing material, then each and every rogue website would add a small percentage of legitimate content and pray that it not be declared as an infringing website. So in this, the Department of Electronics and Information Technology versus Star India, the Delhi High Court in this case preferred a more qualitative approach due to the huge number of infringing content which was available, and hence it decided to block the entire website in this case. The other question which was discussed in the UTV Picture court, UTV Pictures case was, would the court be justified to pass directions to block rogue websites in their entirety? Well, it was observed by the court that it was more of a cost-effective measure. It's much more easier, especially considering that they regularly host a lot of illegal content. So the court observed that it was the best cost-effective measure to address in this matter by issuing directions. The other question which was asked by this court was, how should the court deal with the Hydra-headed rogue websites which on being blocked actually multiply and resurface as redirecting or mirror or alphanumerical websites? So this I had already explained. The court actually referred the case from the High Court of Singapore, that is the Disney Enterprise case, and wherein it was held that the plaintiff again was not obligated every time to come back to the court to take down the same URL which was already discussed and decided by the court. So pretty much by providing all the documentary evidence by way of an affidavit, the plaintiff can go ahead and take down the content, the same URL which was previously decided. So that was held in this case. Now coming to the next topic of intermediary liabilities. This is again a very interesting thing, because considering with the so many e-commerce businesses opening up, and already the giants which are there, such as Amazon, Flipkart, you have Myntra, you have so many other companies, 1mg, we have so many pharmaceutical companies. So intermediary liability is again a very, very important topic, a very important concept, and it's very crucial that all corners are covered to ensure that tomorrow we are legally protected when it comes to enforcement of especially IPR in India. So one of the first cases, a landmark judgment pertaining to intermediary liability, was in the year 2018, wherein this was the case of Christian Louboutin, wherein the High Court scrutinized the ambit of the safe harbor provisions which was envisaged under Section 79 of the Information Technology Act, and it also examined the extent of what is known as an active and passive participation of the e-commerce platform in question. The court also in this case attempted to compartmentalize the plausible e-commerce activities into this passive and active participation, thereby commenting on the very nature of the possibility of the two transcending into the domain of infringing nature, either in isolation or in collaboration. So the defendant argued that their only duty was to take down this infringing content upon either receiving a notice and upon immediately realizing that it was infringing on the plaintiff's IP, relying on the previous Shreya single verdict. Keeping the same in mind, the court hence did not award any damage in this case to the French luxury brand, and accepted the defendant's argument of not conspiring or abetting or not knowingly actually getting into these kind of activities, as it only formulated a mechanism. It was nothing but a plain intermediary. So hence the safe harbor provision was invoked in this case by the Delhi High Court, and no damages were awarded to the plaintiff. Another interesting case which I would like to talk about today is in 2019. This was the Amway India Enterprises versus 1mg Technologies. Now, this was the case which was in 2019. Now, what happened in this case was the court held all these e-commerce giants like Amazon, Flipkart, Snapdeal, 1mg again guilty of tortious interference with the contractual relationships of the plaintiffs with the direct sellers. So this judgment cleared the bargaining position of these direct sellers, as they have ultimate say in issuing what is known as a consent certificate, whether they're okay with their trademarks to be used on these huge e-commerce platforms. So the issue is, for example, if say like a company had a reseller, the reseller would then go to Amazon or Flipkart and sell the products. So, but eventually the reseller was authorized by the main master, the person who owns the brand. So it is these direct sellers who are not comfortable with their trademarks being used, and this was the case. This was the contention of Amway in this case. Later on, aggrieved by the same 2019 decision, Amazon then they filed an appeal, uh, where the bench reversed the decision, thereby then allowing the e-commerce websites to sell their products without any consent from corresponding direct businesses. So this was an observation. This is one of these cases pertaining to all these direct sellers and resellers, and how eventually the resellers were selling all the product on the e-commerce platforms, huge companies here. So I would then like to talk about the latest e-commerce guidelines of 2020, which replaced the e-commerce guidelines of 2019, the Consumer Protection Act of 2019. This was to harmonize and also perhaps to bring in all these e-commerce giant, considering the activities which were happening, considering the gaps which were there in 2019 vis-a-vis all the transactions which were happening on, and how it was not covered in the Consumer Protection Act of 2019. Hence, these new guidelines have come out. So these rules are applicable to, of course, all kinds of business model. It does not restrict into any one of them. It includes both the B2B, B2C, then you have the C2C, then you have the customer to business. So this is applicable to all of them, and under these e-commerce platform, e-commerce guidelines 2020, it is very important that the company has to show four important things. That is the legal name of the entity, the principal address of its headquarters, the name and details of its website, and then the contact details for the customer care and grievance officer. One of the striking things in these e-commerce guidelines is that the consumers can now, when it comes to any kind of a um, product liability, can directly file a case against these service providers and sellers, along with, of course, the manufacturers, owing to a no territorial jurisdiction rule in these e-commerce cases. Now, coming to another case, again, this is a much older case with regard to the intermediate liability, but of course, just a case because it's quite a famous one. This is the MySpace, the Super Cassettes Industries versus MySpace Inc. and other, wherein the single judge bench of the Delhi High Court, via its order, held that the intermediaries were obligated to remove content from their websites as soon as they receive a complaint from any of the third parties alleging infringement. It was also held by the same court that the preliminary check should also be conducted by these intermediaries on all content being uploaded on their website before such material is actually communicated to the public, which of course is highly impossible considering the amount of uh, videos that gets uploaded even on channels like say on YouTube. It's just physically impossible. But this is what was held by the single judge bench, the single judge of the Delhi High Court then. On appeal, then it was the same Delhi High Court then later the division bench held that intermediaries can only be held liable only when they have actual or specific knowledge and not constructive knowledge of existing of the infringing content. And just because a mere again advertisements or any other things that may be put up by them does not amount to actual and specific knowledge, and hence it reversed the decision of the single judge of the Delhi High Court. Now coming to domain names. Uh, Domain names, there is no statutory law which protects strictly domain names in India, and domain names, of course, uh, with regard to one of the Supreme Court cases which I'll be discussing now, the Satyam Infoway versus CFINet. The Supreme Court has held that domain names come within the ambit of trademarks, because, of course, as trademark designates goods or services of one person from that of another. That is why it has held that even domain names come within the ambit of trademarks. Now in this Satyam Infoway case, what happened was, Satyam again is a huge internet company. Then I still remember using dial-up and all those connections. That's when Satyam, Sifi, all these were quite famous. So in this case, Satyam was using a trademark by name Sifi, and it had also blocked a CFI domain name as well. And then CFI Net Solutions, on the other hand, the defendant in this case, also had a similar domain name with the word CFI. So this was the dispute with regard to the word CFI. So initially in this case, what had happened was the City Civil Court, which was where the case was initially filed, had granted the temporary injunction in favor of Satyam, saying that of course CP was a deceptively confusingly and deceptively similar name, and hence the defendant was stopped from using them. Then again Satyam CFINet Solutions filed an appeal before the Delhi High Court challenging the order of the City Civil Court, and the High Court in this case reversed the decision of the City Civil Court. So now what were the grounds on which this was later reversed was, the High Court held that the balance of convenience was in favor of the respondent. It also held that the business of the appellant and respondent were dissimilar. It also held that the respondent had invested huge amount of money in establishing its business and has enrolled more than 50,000 members. And then it also went on to say that this would put great hardship on the respondent, greater hardship, inconvenience, and irreparable injury if this order is not lifted. So this was the reasoning of the High Court for reversing the decision of the City Civil Court, which was eventually then appealed again before the Supreme Court, and then the Supreme Court reversed the decision of the High Court and held that domain names hence come within the ambit of the trademark, and hence today we have a common law right actually when it comes to domain names. So as per this order, wherein it is considered to as a trademark. So if anybody is using a similar domain name, similar to any other trademark, then the same can also be stopped by the concerned plaintiff. So that's about it from my side. Thank you once again to World IP Forum for having me over. Continue to remain safe. Thank you.